Municipal councils and regional district boards are legislatively required to have an adopted procedural bylaw that establishes the procedure for council or board meetings. So, what is a procedural bylaw? Hi, my name is Gloria Mertens, and this is That's My Take, an interpretation and education about village council proceedings. In order to be effective as collective decision makers, each local government council member must understand and follow a shared set of rules. Procedural bylaws include rules for how the business of council is conducted, specifically how bylaws and resolutions are adopted, amended, repealed, or reconsidered. It also includes rules for how minutes are recorded and certified, and how and where advanced meeting schedules and notices are posted, how special meetings may be called, or how public delegations may be invited to have a say at council meetings. Procedural bylaws usually defer to Robert's Rules of Order to guide situations that are not explicitly set out in the procedural bylaw. These rules of order are not legislated, but rather commonly agreed upon customs which help to keep meetings orderly by having a respectful code of conduct, consistent by following the same agenda and procedural format, and efficient by knowing and applying the rules adopted. Some basic procedures that are important for all elected officials to know are: 1. Council and boards may only make decisions by bylaw or resolution. Bylaws are used for actions that affect the community, such as to establish meeting rules, to regulate services, to determine long-term borrowing, to prohibit an activity, or to require certain actions. Resolutions, on the other hand, are a formal record of a decision by council, usually to direct staff to complete a certain action. 2. Prior to each council meeting, the corporate officer prepares an agenda setting out the items for consideration at that meeting. All council members may give a notice of motion respecting an item which he or she intends to present by giving a copy of the motion to the corporate officer during a council meeting. 3. Each council member, including the mayor, has one vote on any question, and decisions are made by the majority rule of the council members present at the meeting. 4. All council members present at the time of the vote must vote on the matter unless they have declared a conflict of interest. So, if they do not indicate how they have voted, the council member is deemed to have voted in the affirmative, in other words, in favor of the motion. 5. In the case of a tie vote at a council meeting, the motion is defeated. 6. Council members who do not agree with the final vote on an issue may ask to have their vote recorded. This allows the public to know their position once the minutes are published. 7. Councillors must appreciate diverse opinions brought forward for reflection and consideration. They must keep an open mind when listening to other opinions and be willing to change their position on an issue if convincing arguments so warrant. 8. Procedural bylaw requirements, code of conduct, and rules of procedure continue to apply to councils during closed meetings as well as to council committee and commissions. A procedural bylaw is supposed to encourage respectful debate. Debate is a formal discussion on a particular topic in a public meeting in which opposing arguments are put forward. It is important to note that debates involve understanding opposing arguments, but decision-making involves weighing these arguments. One disconcerting action of the Village of Ashcroft past and present councils, which I have witnessed or been privy to through association with past councillors, is allowing a motion to die on the table by not seconding the motion. While this may be an acceptable procedure in Robert's Rules of Order, it essentially quashes opposing views from being debated. Any motion can be defeated by majority vote. Suppressing a motion from even entering the public record, especially in a small community, in my opinion, is shameful and shows a lack of leadership. There seems to be no willingness to have a tangle of engagement, and controversy is something to be avoided in the village council proceedings. In fact, committee of the whole meetings used to allow the public to discourse openly with councillors, even though this is not the norm in the province for committee of the whole meetings. This invitation for public discourse was implemented by a previous council after negative feedback from citizens making complaints about council's lack of transparency and public engagement. The amended and consolidated procedural bylaw number 834/841 in 2020 no longer allows such engagement to happen. The conduct of meetings reflects how residents perceive local government operations, and hence the need for a procedural bylaw that establishes these rules of conduct. If meetings sincerely demonstrate open, respectful debate and also allows for public engagement, discourse, and participation, then residents will be less cynical and more positive about council proceedings and the decisions that are made. However, allowing citizens to speak at a designated time on the meeting agenda without acknowledging and bringing these concerns to the table where council can debate them does not further good governance, honesty, nor integrity. Citizens do not simply want to be heard. They want to be listened to. At least, that's my take.